discuss the law guiding service of process, how best to serve multiple defendants. Okay, we are talking about service of process. Service of process of processes. So the first thing you want to find out now is what is a process? What is a process? Especially when used in the legal term, what is a legal process or a court process? So a court process can simply be defined as any document which is intended to be used in a proceeding, any document which is intended to be used in a proceeding, or which is required to be filed in the court registry. Two things there now. Any process which is required to be used in a court proceeding, or any process required to be filed in a court proceeding. Now, when you look at these two purviews, you discover that the first one is something that is like mandatory between the parties to the suit. There is something you must file. You are bringing somebody to court, then the person has to know that you want to bring him to court. Maybe if all you do is that anytime you see the person along the road, you say, I'm going to take you to court. You hear from my lawyer. As far as the person is concerned, you're making noise until you have substantiated either your threat or your boast. And the only way to substantiate it is to do what? File a legal process. So when the person sees your legal process, he will now know how to respond to it. So under that term, we can categorize legal processes to include the originating processes. I will tell you why I'm using the word originating. Originating processes. Now in brackets, when you have stated originating processes, in brackets you can say writ of summons, originating summons, originating motions, petitions, ex parte applications or ex parte motions, etc. So this is for the person who wants to bring another person to court for the purposes of ventilating his grievance against the person. And now the person who is being drawn to the court also has his own processes that he must do what? File. And they include the processes to be filed by the defendant or defendants include memorandum of appearance, statement of defense, counterclaim, set off, rejoinder, counter affidavit, etc. On the other hand, there are processes which the law requires a party to file to show that he has complied with a requirement. The law expects a party to file to show that he has complied with a requirement. Some of these processes are required to be filed by the parties to the suit, while some of them are required to be filed by the court officials. So that is the reason for the second arm of that definition. So the one you file and the one the court official will file. For instance, when a bailiff has served any process, whether on the claimant or on the defendant, he is obligated to file proof of service. He is obligated to file proof of service. But when a party serves a process in compliance with the law, when a party serves a process in compliance with the law, he must file proof to show that he actually served the process. He must file proof to actually show that he served the process. And the proofs here include a delivery note, receipt, and affidavit of service, whichever them is applicable. Affidavit of service, whichever them is applicable. The importance of service is to show that the opposing party, importance of service is to show that the opposing party has become aware or is now in receipt. He has become aware or he is now in receipt of the processes directed at him. He's become aware or he's now in receipt of the processes directed at him. Now, why I say that he has received simply means when he accepted, that's personal service. I'm going to explain that later. But when he has become aware that something has been directed to him or at him, if, for instance, when you press it on his door, pursuant to a court order, or when you serve him through an adult member of the family, or through any other conspicuous means, even if it's through radio announcement, he hears it. So he has done what? He has become aware. Service is very fundamental because it is an issue of jurisdiction. Service is very fundamental because it is an issue of jurisdiction. Especially, I'm doing a note of caution now, especially where the service or process relates to originating process. Where that service relates to originating process, it becomes an issue of jurisdiction. So I'm also going to explain that. A party who has not been served with any process is not bound by the process. A party who has not been served with any process of the court is not bound by that very process. Not bound by that very process. So we just look at a few authorities and then we proceed from there. The first authority is here. Now it's Magaji against APC. Magaji against APC. Magaji against APC is reported 2024, 1 Nigerian Free Law Report, batch 1918, page 1, especially at page 22. Especially at page 22. That the Supreme Court stated, I'll just read it out. That the Supreme Court stated, the essence of service of court processes is to bring the court processes to the notice of the adverse party. To bring the court processes to the notice of the adverse party. And a party who is not personally served a court process must show that the lack of service has caused miscarriage of justice to him. He must show that the lack of service has caused miscarriage of justice to him. In the instant case, maybe also look for these facts of this case, get to read them. Second responder did not give any particulars of how he became aware of the appeal without prior notice. Therefore, the proviso to Order 2, Rule 3, Sub-Rule 1 and B, Sub-Rule 1B of the Supreme Court's rules becomes applicable because by his presence to defend the appeal and legal representation, the Supreme Court is satisfied that the notice of appeal had in fact been communicated to him. So read the facts. So by the time I will start to distinguish between the effect of service, because from what I've been saying, you discover that the effect depends on what particular process is an issue, right? And if, for instance, the other party has claimed that he has served you, the court will not know whether you have been served or not until what you react. Maybe those people who want to do Jankara practice, this thing they call it, remember the past, and all of a sudden you discover the judgment had already been given, and they may be there in your house, they want to leave the execution, and you are embarrassed. So you need to file your own processes to show that you have not been served. So I will also take one other authority, and then I'll go ahead to do further explanation. So this one is the case of Ojo. The case of Ojo against Ose Hale. Ojo against Ose Hale. Ojo against Ose Hale is also reported 2024 4 Nigerian Penal Law reports, but 1928 at page 356. At page 356. This is also important. Very, very important. Is the dictum I'm going to read out here is contained at page 364, where it was stated, service equally on the respondent is fundamental and touches on the jurisdiction of the committee. This one is facing the disciplinary committee. The lawyer, he was to face the disciplinary committee. And this is what the committee found out. That service in question on the respondent is fundamental and touches on the jurisdiction of the committee to proceed with the hearing. Any proceedings conducted without service of the originating processes on the respondent is an exercise in futility. Proceedings without service of the adverse party deny such adverse party of fair hearing. And such proceedings and any judgment derived therefrom is subject to being set aside or overturned on appeal. So, on the effect of non-service, it goes to the jurisdiction of the court or judicial panel in any quasi-judicial proceedings. So, service of even in community setting, maybe you summon somebody before the elders of the community. So, you discover that when you have not appeared before the elders, they will ask questions, right? They will ask, did you tell him, or did anybody tell him that we are sitting today? And if the answer is yes, okay, they will say, call the person who delivered the message so that we can find out what are they trying to do. They are trying to ensure that there was what service or process, whether the native process, whether it's already done or whatever. Why? Because it is fundamental. You don't give judgment behind somebody's back. The person has to be given an opportunity of being heard. So which means why the service of process is fundamental and relates to the issue of jurisdiction is because it's what? It is linked to constitutional right to fair hearing. And you know the Constitution is a grown up. And if the Constitution has given you a right, nobody will deride it. Or nobody will just take it away from you just like that. So that is why it is fundamental, and it goes to the root of the proceedings that is connected to that very service. So we also move ahead, I mentioned the processes before going further. Before a process can be started, that process must be valid in law. Before a process can be served, that process must be valid in law. So I'm going to give you an example and also give you an assignment, a case law to read on that. If a process is served on somebody, at initial, that invalid process remains invalid. But in the interest of justice, the party on whom it has been served will now have to do what? Take a step to nullify it. You cannot nullify it in your house. You cannot sit down in your house and say, this is but they are wasting their time. How would the court know what you have done? Except you do what? You take a step, join issues, so that the court will hear this person and hear you. That is fair hearing. And then the court will now arrive at its own conclusion. You can't be in your house and you're making that conclusion by yourself. So no matter how invalid a process is, so long as it's served on you, you must do what? Take a step to bring it to the notice of my law that this process is what is invalid. And you are seeking to have it done what? Set aside. I'll give you an instance. A client consulted me. They were served with a process. So after we discussed, I took note. I now discovered that we had two things. One, we can explore two options. The first option is to go and strike out the writ of summons for being invalid. The second one is to join issues, raise that very issue, and then proceed. So, but I felt instead of drawing people around, making you come to court today, tomorrow, let's try the first option, which is the fact that that writ was invalid. So I filed a motion for the court to do what? To strike out the writ of summons for being invalid. What happened? A writ had already stayed over 2 years before it was served. It was not renewed. So invariably, there was no writ. So there's not even nothing for me to start filing statement of defense about. Because it's issue of what? Jurisdiction. So a process must first of all be valid before you can talk about what? Serving it. I'll give you one example. Another example is that you may have a process that is signed by a non-legal personality. If you have a process signed by a non-legal personality, that process is what? Null and void. So I refer you to my book on jurisdiction. I discussed that very extensively with a good number of recent cases as at the time that it was written. Now, who is this non-legal personality that can sign a process? There's a matter that, so many matters like that. Let's say A is a senior advocate of Nigeria, and his law firm is A and C, SAN, and Co. And now a process is, prepared and then signed A, B, or A and B, SAN, and then it signs. That is not a human being. Or those of you who have your chamber, what is the name of your chambers? The day you start writing on your clothes, now you'll be posting on Facebook. You'll be putting your non-existent chambers. That has not been built. Now, if you prepare a statement of claim and write Odmoda and Odmod, solicitors and advocates, and somebody signs, is invalid. You understand? Because Odmod and Odmod is non-legal personality. It's better you write maybe AC Odmod Esquire. Under it, Odmod and Odmod Company. Solicitors and barristers and solicitors, you now write your address and somebody signs. That one becomes what? Valid. There must be somebody's name on it. There must be somebody's name. And then a process too may be irregular, in as much as it may not be totally invalid. Irregular in the saying that something you need to do has not been done, but that non-compliance is not fundamental, but it's usually treated as what? An irregularity that can be cured. For instance now, using Odmod, he has filed a process but without seal, without NBS seal. that process becomes what? Irregular. The other party can raise objection. And what the court will simply do is to do what? Go and put this bill. So the matter is suspended until it has done what? Complied. Those people in the earlier matters that were decided along that line, those suits were struck out. But Supreme Court said no. The fact that this person has gotten to this stage is what? Substantial compliance. What the person has failed to do is mere irregularity that can be cured. Okay. Now again, let's assume that there is a law stipulating that a seal, an MBA seal, can expire. Because when you see some of these seals, at times you apply. They're supposed to send you the seal in January. They will send it in February or early March. And on the seal, they will express that this seal is valid until the end of March. You understand? So who suffers it now? Whose fault? It's their fault. Right. So if the validity made you file this process in May, and the other party raises the issue that the seal on this process is invalid. If there is a law strictly on that, that means your process is what? Is invalid. Right. It's no longer an irregularity that can be cured. But if there is a policy that says, since it's our fault, it's the NBA secretariat, don't bother with it, or a judge, someone can look at it and say, because we have taken judicial notice of how these things are done, the court will close its eyes in the interest of what? Justice. Right. But bear in mind that before you even start talking about service, that process must first of all be what? Okay. So we'll move away on the validity of a process. See the case of Naj against Indivisi. Naj against Indivisi. Is he here? Naj against Indivisi. 2024. 5 Nigerian Free Law Report. Past 1930. Page 163 is a Supreme Court decision. So I recommend you read it. Now the next thing is how to effect service. How to effect service. The procedure for effecting of service is as stipulated by law or the rules of court, which is a subsidiary legislation. The procedure for effecting service of a court process is as stipulated by the law or by the rules of court, which in itself is what? Subsidiary legislation. The process must be served on the person of the adverse party. That's personal service. It must be served on the person of the adverse party. Especially in cases of originating processes. That process must be personally served on the addressee, the person on whom you want to effect the service on. So you must ensure that that service is personally effected on that very person. But when that person cannot be found for the purposes of effecting personal service on him, when that person cannot be found for the purpose of effecting personal service on him, then the other service can be resorted to. And this is called substituted service. So I will explain substituted service and explain something again that looks like substituted service, but which we cannot for sure say is substituted service. Now, substituted service by rules of some courts may be effected even when no attempt has been made. It may be effected even when no attempt at personal service has been made. And this may be possible where it is believed, that by the circumstances of that case, it will be more convenient to effect service by substituted means, or where it will be cumbersome to embark on personal service. For instance, where you know that this person is not within the range, is not immediately within reach. So that means it will be cumbersome looking for him. Maybe he's a businessman who goes from one place to another, or he may be a pilot. So you don't know where to get him at a particular point in time. In that case, you may not even bother to attend personal service. But in that way, your affidavit in support of your application must show that you know what this person does, and you also show that he's not a person to be tracked easily, and that he lives at a particular place. We're going to talk about that, and that it will be more cumbersome for you to start carrying the bail for the court, flying around Nigeria to look for him. And also that it will save cost. So the law is also taken off your pocket, especially in a time like this. It will save cost to effect service by substituted means. So these are the major reasons. And let me also add that it may also be that there is the possibility that this person will evade service. That one is speculative, but in a good number of instances, the court will do a community reading of all their factual arguments in the affidavit, and if convinced, the court will say, okay, no problem. The court will grant your application where you believe that he may be evading service, so that if you will try, you won't get it. But most of the times, when you are relying on that fact that this person is evading service, you must show that you have made an attempt to serve him, but you didn't get it, maybe 1 time, 2 times, or 3 times. And the bailiff will be able to do his affidavit accordingly to show on so date and when there at his last known place of business or abode, I didn't meet him. Mind you, we are drafting now. And then on a second day, I went to so place, I didn't get him, and I believe that he knows there is a suit against him and that he's trying to evade service. That is when it will make more sense for the court to now grant your application. And then I did say that there is another form of substituted service which we cannot actually say is 100% substituted. Let's say, for instance, I want to get to Mr. J. Udimodu, and I know his address where I can get him, but I believe that he's not always there. And then I want to post the process to him by DHL, addressed only to him. Even if the letter gets to his office and the secretary receives it, will the secretary open it? Because he's bearing Udimodu's name. So what the secretary will do is to wait until he comes and gives it to him. Once he opens it and reads it, that's personal service. Right. So most at times too, it will look as if we will pray for the court to grant us the order to serve him through courier service. Some of the time people will think it's substituted service. But when you indicate that it will be addressed personally to him, that will also amount to what? Personal. The same thing will also happen if I know his email address and I say, my Lord, grant me an order to scan it to his email. Once I scan it to him, his email is personal to him. That is also what? Personal service. But you're effecting it in a manner that looks like what? Substituted service. Assuming you're asked to distinguish, discuss. So you need to also get to know those areas. Now, how do we effect substituted service? I've already covered them, but I'll simply mention. Substituted service can be by pasting on the gate, entrance, or any conspicuous part of the respondent's last known place of abode, because you don't know whether he has passed out. But that's where you know he used to be. That is last known place of abode. So you can pray that it be pasted on that either the door, the gate, any conspicuous place like the wall. You can also pray that the process be pasted on the walls of the court. There's nothing wrong at that. Paste it at the gate of the court, any place at the premises of the court, whether the person comes to court or not. Somebody who knows him may read it. Oh, and then call him, or do you know that there is a process against you? It is pasted on the walls of the court. You have become aware of it. And one funny thing is that once that order is made, the court expresses it to be what? Sufficient service. It is expressed to be a sufficient mode of service. And then you can also serve through a worker, a servant, agent, or an assigned of the respondent, the person you want to serve. Okay, it can be respondent because you're going by substituted means, or the defendant, if he's a defendant, or the claimant, if he's a claimant, as the case may be. But I may use the word addressee so that you understand me properly. If, for instance, somebody is at your side, is at your land, building, and he doesn't want you to know him, like the case I did in Kubwa, we wrote to the lady who sold to our client, and the lady won't respond. We'll go to where she was running a school, give it to her, she will just behave anyhow she will. Meanwhile, the instruction was going on. So initially we thought it was her after selling to us that she started the business. But somehow we believe she must have sold it. So we went to court. After we sued her as the first defendant. The second person now becomes unknown person who is occupying, you mentioned the problem, because we don't know the problem, we are not spirit. You know, so that in our motion too, we ask the court to summon the first defendant to appear in court and disclose the identity of the person building that. By the time we served, we said we don't want, if we do by pasting, it was during the rainy season, anything could happen. So I prayed my Lord to permit us give it to one of the workers. You know, so when the bailiff got there to serve, and the person look at it, okay, senator is not, senator he has traveled abroad. We then had a line, it was a senator that was building the house. So I will say, whoever he is, just tell him, at least he pays you people. Or you give it to the contractor who has direct communications with him. So that is a form of what? Substituted service. All right. Then the scope of substituted service is not foreclosed. It all depends. Maybe you know his best friend, or the person, the person's best friend. And so, okay, if you serve it to this person, it will, on this person, definitely do what? Get to the addressee, because they are best friends. But in the affidavit, you must also state, how do I go about, how do I apply for substituted service? Substituted service is made by way of application, by way of motion ex parte. Motion ex parte, supported by an affidavit and a written address. And it must be anchored pursuant to the relevant provisions of the rules of court. Like I promised, next time I'll do the rules here. So it may go like anybody with the rules. Okay, open service for me, so that you can practice now. Open service. So the heading will go like, in the High Court of Abia State of Nigeria, all in capital. Second line, in the High Court of Umuahia Judicial Division. Up and in capital. Third one, holding at Umuahia. Then you go to part of your right, shift to your right H1. You write suit number. Let's say you've already found the root of someone that they have given you the suit number. You know. So write the suit number. After the suit number, you then write between by your left hand side. After between, you now put down the names of the parties and their status in the application. Let's say the plaintiff is Mr. ABC. You now write ABC, claimant / applicant. ABC, claimant, applicant. And there is normally in use term used as versus. But versus, like we know, is usually applied in criminal matters. But just write and. You know. Now defendant may be XYZ. Write XYZ hyphen defendant. You don't put respondent because you are not putting him on notice. He's ex parte. Then you will now do a heading of the motion. And the heading of the motion will simply read something like brought under order 7, rule 6 of the Abia State High Court Practice and Procedure Rules 2021. All underlined and in capital. Some people will also add, and within the inherent jurisdiction of the court. That is wrong. Inherent jurisdiction of the court comes when there is no statutory provision. But when there is a statutory provision, the court can act based on that. There's no need to talk about inherent jurisdiction. Inherent jurisdiction simply means like you're filling in the gap where nothing is there. You're only asking the court to do what substantial justice. So we have drafted our heading now. And then, in the body of the motion now, you simply write, this honorable court shall be moved on dash, let's say Wednesday, the dash day of dash 2024, at the hour of 9 o'clock in the forenoon, or so soon thereafter, as the claimant applicant or counsel on his behalf may be heard praying. You now put your punctuation and then situate your prayer in the middle as if you're doing a quotation. Right. Order of the court for the defendant to be served by substituted means, to wit, testing same at his last place known of abode as number 3 Nama Road, Umuahia. You have done that. So, and then you have done the major prayer. Then there is also an omnibus prayer, which comes below that. And that one is usually put, and for any other order or orders. Or you can say further orders. For any other order or further order or orders, as the Honorable Court may deem fit to make in the circumstance. Then move to the next paragraph, date. Dated at Umuahia, this 13th day of May 2024. And then see by your left, some people make mistake going by the right. By your left, you now tell us who you are. J. Udmod Esquire. The more than Udmod and Co. You now put your address. Supreme Court of Nigeria. You don't put address for service. You don't put address for service. Why? Why won't you put it? Because it's an ex parte application. Then after that, you return the same heading. Just copy and paste to the next page. And then with the heading, what you are just only heading, don't copy including the motion. So you only copy the court, the parties, and then you paste and then write affidavit in support of motion ex parte. Then in that affidavit in support of motion ex parte, so you will now begin to tell us your story. A good number of times, lawyers make this mistake. They use their clerk to swear to an affidavit. That's being lousy. What happened to your client? Use your client's name, because most of the times, if there's a lie on oath, they will come for your client. If there's a lie and you have used your junior lawyer, they will come for him. Also remember what happened to the Junior. Use your client always. The person now say, I, ABC, male, Christian, Nigerian citizen of, he puts his address, do hereby make oath and set as follows. 1, that I'm the claimant in this matter. 2, that I find this writ of summons on so they give the date. 3, that on so date I took the bailiff of the court to number blah blah blah, being the last known place of abode of the defendant for the purposes of effecting personal service, but we could not meet him. 4, we repeated the same trip on so we didn't meet him. 5, we also repeated on so we didn't meet him. Then the next paragraph, that I verily believe, or I sincerely believe, that the defendant is evading service. That any process pasted on the entrance of number so being the last known place of abode of defendant, we definitely come to his knowledge. And then you conclude that I make this oath solemnly, conscientiously, in good faith, believing same to be true and nothing but in accordance with the oath act. Then you put your name, the other side, put a line, deponent, sworn to before me at the High Court Registry Omaya, this dash day of dash 2024, before me, Commissioner for Oaths. You're done with that. And then you now do your written address. Written address, the same heading, that's the parties, the head of the court, and then the parties, and then the next, the line saying written address in support of motion ex parte or in aid of motion ex parte. Then we start by introduction. 1.00. This is a motion ex parte brought pursuant to order, blah, 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 on this group. And for any further order as the honorable court may think fit. Assuming you have a schedule to the motion, you can also mention the schedule. And then the next paragraph, 1.02. The motion is supported by an affidavit of 13 paragraphs sworn to by the defendant, by the claimant applicant himself. Then you now move to the next one, which naturally will be the fact of the case. And you just give the summary, concise fact of the case, that since this case was filed on so day, you have made social attempts to serve social person. My Lord will most humbly refer you to paragraph 3, 4, 5, 6 of the affidavit in support of this motion. But in all these days, the defendant could not be seen. And we have also averred that we believe the defendant was evading service. And we believe that any process served him on his last known place of abode by pesting and spraying will briefly do what get to his knowledge. And then the legal argument, the next paragraph, that by virtue of order this with this, my Lord is empowered to make this order. So you can stop by like that, or if you want, you can say, my Lord, order 7 rules stipulate that when it appears to the court that for any reason personal service cannot be confidently effected, the court may order that service be effected in any manner, including electronic mailing, by which it appears to the court that the document is likely to come to the knowledge. That's the power of the court. And I have said, my Lord, out of the ground, the classes for effecting this service, we have chosen so as the most convenient. May it please, my Lord, you conclude, date, put your name. So you have done that, you have drafted that. Right. Then we will move further. We have been able to look at how to effect service, how to draft it, to make this work. Now again, when there's something I want to put in. Okay. Now, service also on certain categories of persons may differ by the provision of the law. Service, mode of service on certain categories of persons may differ according to the law. For instance, when an infant is sought to be served, Now go back to your rules of law and tell us how to serve an infant. How is an infant expected to be served? So naturally, that is Order 7 Rule 17. By Order 7 Rule 17, it talks about where an infant is a party to a suit. Service of any process on the infant may be effected by delivery of the process to his father or guardian, or if none, to the person with whom the infant resides, that's the guardian, or under whose care he is, provided that personal service on a minor who is over 16 years of age, living independently or doing business is good and sufficient service. So if the infant is over 16 years, and I don't know what kind of business a 16-year-old child is doing. You know, you can Yahoo at 16. I don't know. I don't know the age for Yahoo is it. Then we also have provision for lunatics, how they are served, civil servants, partners, local governments, companies. But I just want to make a brief comment on the company. The rule in Mark against AK, I get a citation later. The rule in Mark against AK used to be that any process meant for a company cannot be served by substituted means. Processes meant for a company cannot be served by substituted means. In other words, it must be served on any of the directors or a highly placed officer of the company. So that was the rule in Mark against AK on substituted service. And I did an article on this, and there is also a colleague of mine that did an article on the fallacy of the rule in Mark against AK. Because I believed, I was the view that that very decision was by inquiry. Now, how do you know a director of a company? How would you even know who is a top officer of the company? You know, so that was the rule. But in course of time, there was a kind of watering down of that very rule. There was a watering down of that rule to include that such service may be effected on any officer of the company. On any officer of the company. And when we thought that we were like winning, that it was giving us exactly what we were looking for, then another decision came that a service of process that was served on the gate man in a company was improper. That the gate man wasn't a principal officer of the company. For me, is he not even the most principal officer? If you leave that place, you know the danger that will happen to the company. So, and when Kama came, especially Kama 2020, Kama tried to also soften it by saying, if the place of business, quite unlike before, is at Abuja, you must go to Abuja to serve. You can serve at any branch within your jurisdiction. So the strict rule of serving at the place of business has shifted, but what still remains is that of substituted service. But with a little amelioration that you can serve on any officer of the company. So, and we are still waiting for an opportunity to prove that the gate man is as important as a director. Despite his salary, can the director do the gate of the work of a gate man? It doesn't appear feasible. It doesn't appear feasible. Now there is also another issue on the extent of applicability of substituted service. As was shown, that's under fundamental rights now. In Ngige against Achuku, I also have an article on that. In Ngige against Achuku, Somebody was served by substituted means in fundamental right action. And they said, no, the rules did not speculate or make provision for fundamental right to be served by substituted means. That the rule simply said, made mention of substituted service without limiting service to substituted service. That's my argument now. Without limiting service. What do we now use? What rule of construction? The generis rule. Ejidem generis rule. So I purposely served a process through substituted means. I knew the issue would come up. So they filed, you will read it in that my article. The other party filed a counter. I was prepared for him. I told my Lord, the president CJ now, when he was sitting in Aba. So my submission was, my Lord, if the essence of service at all, whether personal or substituted, is to bring the existence of process to the notice, knowledge, attention of the addressee, what is wrong that I have served by substituted means. And now that he has seen it, the process, so why is he complaining? He is with the process in his hand. And then I say, my Lord, I believe that I know Court of Appeal is a superior jurisdiction to your own. But my Lord, this is a case that calls for activism and application of. I was careful not to use common sense. So I said something else that depicted use your senses. Why persuasively, you can even insult somebody while begging. So why persuasively putting it forward? And I was happy that in the end it happened. And my article 2 was made reference to by another Court of Appeal decision, and that changed the rule. So in fundamental right now, you can serve by substituted means. Right, you can serve by substituted means. Now, another issue that will normally come up is, I take 2 more issues is when a service is irregular, what do you do? Does it invalidate the action? Okay, you also remember our erudite, a professor suing a judge on the issue of service, Obioke's matter, Obioke against Wabeze. You have read it, so better go and read it. And then, what the Supreme Court has ruled, and if you look at that decision critically, you discover that the stream of that decision is like dual. The first place, if a writ of summons has been properly filed, but irregularly served, it does not vitiate what? The action. It doesn't vitiate the seat of writ of summons. What will be the attitude of the court? Is to do what? Set aside the service. I said, my friend, serve him properly. You understand? But when you look at it and look at the issue of substantial justice, somebody has come to court. I was not properly served, but you're holding it. Do you understand? My Lord will say, okay, but you have it. Return it. You return the process. Cancel, serve him. Give it back the you won't be speaking grammar. And then you set precious time. Right. So that is also the implication of that. And then I also want to talk about who is empowered to serve. By the rules of court and law, the person who is properly equipped or appointed to serve is an officer of the court called the bailiff. The bailiff of the court is the staff of the judiciary, the staff of the court, on whom lies the duty of effecting services. Even if the order of court is do it by courier service, give him the money, let him go and post it. Right. After posting it, he comes to the post office attaching the receipt or the tracking document. But a good number of times, we as lawyers will do that. But it's not wrong. We do it because the law allows for what is called special bailiff. A lawyer is a special bailiff, but in most of the times, not in originating process. Not that first one that you file in court, but subsequently, other processes can be filed can be served by the lawyer as a special bailiff. Any other staff of the court can also collect the process, signed. Original copy for service collected by me for purposes of effecting service. He signed, it becomes what? A special bailiff. Good. And then the person after serving will now do a proof of service. Just prepare affidavit of service to show that you are the one that did what? Effected the service. Then again, if a matter is already pending, the defendant has a lawyer now. Nothing stops me as claimant's lawyer from doing what? Serving directly on the defendant's lawyer. We call it inter-counsel service, counsel to counsel service. So that is also recognized by law. And now, a person who is arguing or denying service is expected to do what? To debunk service. How do you debunk service? If they said that they have served your client, what do? Apply to the court registry. Let them open the court file to see if there is an affidavit of service. Apply for CTC. Avail yourself with the CTC. Look at it, you are now fighting against that proof of service, right? You now do a counter affidavit, traversing every lie in that proof of service, saying that I have not been served. On this day, they said they served, just like one we are doing now before. They said they served this person over 2 years ago, and they have been coming to us asking for judgment. But we are lucky that the court went on election matter assignment, and the court is back now. They are asking for judgment. Somebody in court mentioned it. Is it not your client that was in so house? Is in this photo, they are asking for judgment, so court. He said what? So we started making applications. So immediately I saw the proof of service. I asked a young man, bring your particulars. As at the day they said they served him, he was so lucky. That was the day he was defending his project. Then we wrote, because we still had ample of time, we wrote to the dean of his faculty, and they said yes, attaching the list to show that he was present in the defense. And then what else did I need? I don't do a counter affidavit. Exhibit the fact that he was somewhere else when they claimed that they served him personally. So once, and we're waiting for the ruling of the court, once that is held, the court will look at it and say, no. The service is what is talked about. I don't believe there was any service. He has shown that he was not served. If my Lord makes any further affidavit, serve him, I will raise an objection. Why would I raise objection? I said the day the court will agree with us that my client was not served, and if the court orders that he be served, I will raise objection. Why would I raise objection? Simple. I said this writ has taken 2 years. So once my Lord agrees with me that he was not served, that means the writ is what? Is stale. It has become invalid. So there is no way my Lord can ask us to accept an invalid writ. All right.